4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 5532 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
Well, welcome to the studio. Welcome to the microphone. Andrew Bell from Bell and Senior Lawyers. So I'm reading now. I shouldn't be reading. Put the paperwork away. Good morning, mate.
Great to be back, is it, Colin?
It is. We were wound up in a fairly lengthy discussion off air, which will probably turn into a radio program down the track. And lo and behold, the promo finished. Well, it is time for the program, and it is your program. This is your opportunity to get a little bit of free legal advice this morning, and we'd love to hear from you. Do not leave your call to the end of the program. 07 5520 8888 is the number to call. And we've got a great little program. I'm learning things every day as to how the law has changed over the past couple of years. And the topic this morning is what parents need to take home, and it is from the point of view of family law. So it's going to be an interesting discussion this morning because I learned quite a few things just reading the notes along the way. So Andrew, maybe I should leave it to you to give us a précis, but today we're moving into children and parenting, and rather than going through specific court decisions, we want to give listeners the practical considerations to actually take home.
Oh, that's right, Colin, and it's a great way to frame it. Parenting affects everyone who separates, who has children, whether or not they ever go near a courtroom. So today is about the principles that you need to understand or a family member needs to understand should they be going through a separation that involves children. So the law keeps changing in this area, and however, there is one most single important factor that needs to be taken into account, and that is the interests of the child. So the courts, in any decision around parenting, the number one deciding factor that they're supposed to consider is what are the best interests of the child, and then those interests come first. So that shapes every other decision around parenting law. It might sound obvious, but it's difficult to hold on to in the middle of a separation because everything feels personal. Everyone wants to bring up points and things that have happened in the past. But ultimately, it really should come down to what's the most important thing for the children.
Look, it is a very emotional time, and yes, things can get muddled up and priorities can be skewed. But we've got our first caller. Before we dive into the topic this morning, we're going to start with George. Morning, George. Ask your question of Andrew.
Oh, good morning. Andrew, just one simple question. With the census coming up now, I've heard a lot of people are saying that they don't want to fill out the forms and it's an invasion of privacy and all this. Can you actually be fined if you don't?
My understanding is, yes, you can be fined. It's a Commonwealth offence, and you can be fined up to $364 a day, according to the Bureau of Statistics. So it depends on where you're going to be on the night of the census. The person who's in charge of that property needs to fill it out for the people who are going to be there on that particular date. But if it isn't completed, then there are financial consequences.
I've heard different, the general consensus of people talking about what you can do to avoid filling it out. Some people say go camping on that night and make sure no one's home on that night. And if there's no one home in that house on the 11th, is there an escape out of it or not?
Well, if no one is at home on that date, then what would get filled in would be a declaration to say that there was no one there on that date. But be aware that knowingly providing false or misleading statements is also a crime, and it can result in a fine of up to $3,000.
Yeah, sort of. you hear all these people talking about, I'm going camping on that day or, on that night.
Jeez.
So they may be doing these things, and I'm sure there is an element of fraud, but I'm not going to be encouraging people on the radio.
Out of interest, mate, can I ask the question as to why you were considering avoiding it, if you are?
I just find some of the questions not only silly, but sort of, a bit invasive. I can't see why it would be of any interest to anyone in the government to want to know how many bedrooms you have in your house and things like that.
Those questions, George, actually do have a lot of practical use. And in my dark past, I was a data analyst for very large companies, and understanding the future needs of even where you're planning to put your electricity, where you're planning on putting internet lines, etc. The more people know about the sorts of demographics that are in those areas, the better that the government can actually plan for essential services so they're ready when they need it. I think it's actually crucial that they get an accurate picture of what's going on. From a legal and cybersecurity perspective, I am concerned that data needs to be de-anonymised to the point where it can't be used against any of the people filling it in personally.
Agreed.
But so far they seem to have a pretty good track record of that.
Yeah. Okay, that's good to know anyway, I suppose. Yeah, okay, it was just a question that I just never had. You hear that many people talking about different. Another aspect of it is they say that it can only be done online. Now, people like me, I wouldn't have a clue how to do anything like that online, so they used to deliver a paper copy once, but I'm not sure if they do that now.
I'm pretty sure you can order a paper copy if you're unable to do it, and I think that they're sending everyone a letter with a phone number, George?
Yeah, I did get that letter, actually,
Okay. Well, the only thing I can think of for you to avoid it is to travel overseas, and then you don't have the requirement, but otherwise there's no legal way that I know of to avoid it.
Yeah. Okay, thanks very much for your help, Andrew. Appreciate it.
Thank you, George.
Thank you, George. All right, we're moving on to our next caller now. It's Nadine. Nadine, ask your question of Andrew.
Oh, hello. Good morning, Andrew and Colin. When a will is established, meaning officially by the person and the chosen lawyer, could you please, Andrew, explain how often does that will is required by law to be reviewed officially by that person and the lawyer, even if no important change of circumstances occurring for a few years? Thank you.
Nadine, so a will, once it's in power, if it's properly executed, never technically needs to be changed. However, people's circumstances do change all the time, laws change all the time, things people own, their relationships with people, other people die, change on a frequent basis. It's our recommendation to our clients that they at least review that everything in their will is current every 3 years. However, there is no mandatory time. You could write a will when you're 18 and then it would still be valid when you're 100. It doesn't expire as long as it's your current will and it accurately and it was signed and executed properly.
Thank you. And quickly added to that, Andrew, how is the will stored by the lawyer nowadays with that high technology and everybody being so scared of confidentiality, which is broken, as you know, quite often online, and the Privacy Act? How is it stored?
So solicitors have an obligation to keep data private for their clients, and it depends on the client services agreement you have with that lawyer about how they'll commit to store your information. However, wills are an interesting one because unlike virtually every other document, the physical copy of the will is the most important copy that needs to be retained. So at my office, we scan them in case something happens, which gets stored in an encrypted secure cloud. And then we also have the physical copy in a safe, either on-site or off-site. Because if once the person dies and if it's their current will, we need to actually send to the Supreme Court that physical copy, the original of the will, for it to be recognised as part of probate. You can store it at home, but we recommend that if there's a chain of custody for people signing things in and out, it's much more likely that it's deemed to actually be your will, not be tampered with, not be destroyed by someone who's unhappy with it. So typically the lawyers will ask if they can keep it on their premises.
Thank you so much, Andrew, and you two gentlemen have a lovely day.
Thank you very much, Nadine. You too.
Thank you, Nadine. Now, if you would like to have your questions answered live on air, the legal questions, of course, that doesn't have to be like these last two questions were, centred on the topic of the day. All you need to do is give us a call right now. 0755 20 8888 is the number, and we might go to a message from our sponsor.
The greatest gift you can give your family is certainty. Our trusted sponsors, Bell & Senior Lawyers, can help you put the right plans in place, from wills and estate planning to family and property law. Take the first step today. Call 07 55 32 8777 or visit bellsenior.com.au. Bell & Senior, trusted guidance when it matters most.
All right, we are back with Legal Matters with Andrew Bell from Bell & Senior Lawyers. The topic of the day is family law and what parents need to take home when we're talking about child custody. Now, there's been some changes to the law. The child's best interests come first, not the parents, when we're discussing this, Andrew. So I will let you lead back into the topic.
That's right. So what that means is that every decision, whether it's where the children, where they live, how much time parents get, how school or medical decisions are made, religious decisions, where the children can travel, should all start from the position of what's the position of the child, not from a sense of an entitlement or payback or scores that this child did this last year, therefore this other person gets the decision. Parents who frame their position around what they deserve to get is likely to be an argument that's going to fail. The parents who succeed in the system are the parents who can genuinely explain why their proposal is better for the child. And that ties into something else. So we had there was a perception of very uneven decisions around where the children got to stay after parental separations. The law then changed to say, well, the default position is both parents get 50% custody of their children. But that got rolled back by the Labor government in 2024, so there's now no presumption that starts at 50-50 custody. The court will look at the safety of the child's own views, their developmental and emotional needs, and the parent's capacity to meet those needs, and then work out what arrangement fits. So we've gone back to there is no default rule in parenting disputes, which upsets some people, and it also has follow-on effects for things like child support, where the child support rules had been changed to favour if there was 50-50 custody. It was likely that each parent bore their own costs. Those have also been pulled back, and they're looking at the actual needs of the children based on where they're actually staying.
So parents should not walk in assuming half the time is the best place to start.
That's right, and that cuts both ways. So some arrangements will still land at 50%, and if that's what the parents want and that's what's deemed appropriate by the court, then that shouldn't be a problem. And not everything has to go through the court, so you could come up with a parenting agreement before going to court, or you could come up with an agreement and ask for it to be lodged in the court so it has the power of a court order. The court will make sure that that looks just and equitable, but provided both parents are reasonable, there's no allegations of abuse, and they can both properly care for the children. If it's mutually agreed, 50% could be the go. The problem is if that's not what both parties want, then how do we untangle and work out what is the best outcome? And again, it's not a win or a loss for one particular parent, or even a decision based on their parenting styles. It comes back to what we were talking about before. What is the child's best interests?
And that's a great position to start and have in the back of your mind, I would imagine. All right, this is a Talkback program. It is your opportunity to get a little bit of free legal advice this morning. We have 12 minutes left in the program, so if you're hoping to ask a question, now is the time to run to that telephone and dial 0755 20 8888. Please don't leave it to the end of the program. We'd love to hear from you right now. Now, Andrew, if one or both parents have an issue with or concerns with the other parent's behaviour, how does that work in this equation?
So this is what would come down if you were applying to the court for them to make a decision about the parenting. The court may also appoint someone called the independent child's lawyer, who's a lawyer who actually goes into bat for the children's interests as opposed to both individual parents.
Wow.
The parents would then put out their position in an affidavit that would actually go through and say, this is what I'm looking for, here are the events that I'm concerned about for the other parent, here's any evidence that I have to support that, and they also have to put down what their desired position is. So anyone who may be looking to have the children, they say, well, I want them 50% of the time, I want them just on weekends, I want 100% custody. And then the other party needs to put in what they want, and the court will then evaluate those, and people may need to give evidence, etc. They also now have the ability to order things called parenting reports, where an independent person can come and interview all of the people involved and the children independently, etc., and then provide a report to the court about those parenting matters from a more independent perspective. Child psychologists can be involved. There's a lot of things that go into it, which does mean that it becomes quite a lengthy process and can be quite a stressful process. And people really do feel that their parenting is on display and being judged. But it's really more of a proactive thing rather than a retrospective thing. So again, they're looking at where have the children been, but also where are they going to be? What is best for that child? Where is living make the most sense for them? If someone lives an hour away from their school and one is 5 minutes away, should that child be moving schools? Is it appropriate for them to be driving an hour each way to school each day? All sorts of things get taken into account. What do the children want? Are they old enough to make that decision? We're often seeing that if people have 16-year-old teenagers and they're breaking up, it pretty much will go with where, as long as it's safe, where does that child want to live? Regardless of any argument from the parents, if the child feels most comfortable and feels that they can thrive best in a particular location and there's no undue influence being placed on that child, the court will take that very strongly into consideration. 5-year-old's perspective, not so much.
All right. Well, we've got a few callers, Andrew, so we might take those. We're moving now to Laura. Laura, ask your question of Andrew.
Is it okay to change lawyers? I have just completed doing my testamentary trust and will. Mm-hmm. Then I was then recommended that I should proceed with doing my divorce. We were separated for a while. I met the initial divorce lawyer. I just didn't feel comfortable with her. Can I just change the company?
Absolutely. You can change at any time your legal representation. Now, lots of lawyers probably won't want to hear that, and it'd be sad if you were with my company and wanted to part ways, so I'd suggest that you talk with them first. There's a benefit of sticking with one lawyer in that if they already have all your files, they know who you are, they have all your information, that they're working ahead. But if it was a testamentary trust and not a divorce that was created, a lot of that information isn't particularly relevant. Yes, I would say go get some appointments with a number of lawyers and get one that you feel comfortable with. It's a bi-directional trust relationship. If you don't think that they're acting in your best interests or understand you or will act in a way that represents who you are, then they may be the best lawyer in the world for someone else, but if they're not right for you, that you can go around. You would have signed what's called a client services agreement, and in that will give you the terms of what you need to do. Typically, you do need to make sure you've paid all your bills before you switch lawyers, but yeah, you can switch a lawyer any time in any proceeding generally.
No, I had to pay $429 for the initial meeting. Mm-hmm. I haven't signed a contract just yet.
Well, you're free to move at any time then.
So I'm free to move. And they won't get offended because they've done the will and the...
Well, they might be offended, but that doesn't really matter in the grand scheme of things.
You're paying them to do a job, and whether they're offended or not, they have to do that job.
Okay. It's just that I don't feel comfortable with the next lady. The lady that did my
ring around,
testamental
get
trust.
some consultations and work out where you feel most comfortable and go with that lawyer.
Especially with family law. Having seen that here, there's examples of people who've gone around and interviewed 5 or 6 lawyers until they found one that they were comfortable with, Laura.
All right. Okay, thank you so much.
Thank you.
Thank you. Bye-bye.
Bye-bye. All right, we're moving on now to Len. Len, ask your question of Andrew.
Good morning, Andrew. I have I received an email on the 17th of July. First of all, I thinking it was spam, but I looked it up on Google and such a thing exists. It's a class action against Amazon in the United States.
Mm-hmm.
And and I'm included, allegedly, as an Australian because I'm a customer of Amazon.
Yeah.
And it wants me to opt out, but it's very complicated. So I'm not sure what to do.
Well,
so
it's very complicated.
From
It's probably very difficult here. Now, I've been asked to look at a number of class actions from America for Australian citizens, and typically you have to establish your standing as American as part of the requirements. So if you have no tie-in with America except for a customer, often you're not eligible and you'd have to wait for a similar Australian class action to get involved. Now, often these things have helplines. You're not interested and you just want to opt out. Well, they should be quite easy to opt out. There should be a form to say you're not interested, or I would reply and ask them how do you opt out.
Okay, all right, thank you. They don't make it simple on the email, so would it be of any advantage to talk to my lawyer about doing that?
I suspect it would cost you more, and I don't think that there would be a lot of ramifications. I think I would just write to them and ask them how do you opt out.
Yeah.
Because an Australian lawyer may not even have the American experience to be able to give you the right advice.
All right. Thanks, Andrew. I'll respond.
Thank you, Len.
Thanks very much.
Thank you.
Bye.
Andrew, just on the back of that question there, if you just ignored the email, decided I don't want to be a part of it, I'm not going to provide any information, isn't that just enough to opt out of such a thing?
So American class action law is different than in Australia. In Australia, you typically have to opt in, and they will write to you often and say, we believe that you're in this class. Would you like to opt in? They will give you a deadline that you have to opt in for, because I've got a few people recently who've wanted to opt into something that was closed. If it's closed, you then have to separately apply to the court to join the class action. But yes, you have to actually apply in Australia. In America, sometimes they're sweeping and work the opposite way, and then they will send a check to somewhere on record if they believe it's valid. But what that does do is it extinguishes your rights should you want to sue them again in the future. However, it sounds to me like Len's not interested in suing Amazon.
No.
So I think that the ramifications, if he's opted in or opted out, are pretty low, and these class actions for something like that would probably only give him a couple of dollars. But as I said, in Australia, you have to proactively choose and then identify, often with a statutory declaration, that you are a member of the class. You know, I am an Uber driver. I did receive financial advice from these people. I did whatever.
And away we
in
go.
America, it's more, we think you're a member of this class. We're going to assume you are unless we do something else.
Okay. All right, we're moving on to John now. John, ask your question of Andrew. You there, John?
Good morning, Andrew. Good morning, Colin.
Morning, John.
Andrew, I phoned you a few weeks ago about my enduring power of attorney, and I did find the original form, but I can't find now my original form for my health directive. If I get a copy and get it certified, is that good enough?
Well, no, but normally the original would get filed with Queensland Health, so I would call Queensland Health and ask them if they have an advanced health directive on record for you.
So that would be sent automatically from the lawyers to Queensland Health?
Well, your lawyers probably would have done that on your instruction. There is a website or an address that you can send an advanced health directive to, so it actually gets part of your permanent medical record. So if you don't have it and you just have a copy, my suspicion would be that the original is actually with Queensland Health.
Right, and that's fine. The copy, if I became terminally ill, that the copy I have would be sufficient.
No, it wouldn't. A copy you have wouldn't be legally binding. They may choose to follow it, but a copy wouldn't be sufficient if they decided to go against your wishes for someone to sue them or for you to sue them if they hadn't actually followed. They need an original for the Advanced Health Directive to be valid.
So if I go back to the lawyer and get them to...
well, just ask them if they submitted it to Queensland Health. Because if they have and you've got a copy, then I would bring that with you to any medical treatment and say, well, here's a copy of my Advanced Health Directive, the original's on file, and they should follow it. But if there's nothing on file and you've just given them a copy, they may choose not to follow it and they wouldn't be bound to.
All right. Thank you, and thank you for your valuable time, Andrew.
Thank you, John. Good luck.
Thank you, John. Well, that was a very diverse set of questions. Andrew, we've got a couple of minutes, or a minute left in the program. Thought you might like to summarise the topic for today.
Yeah, well, essentially we will cover this again next week in different aspects, but if you have children and you are going through a separation, the number one thing that the courts will consider in making a decision, so this should be how you frame any arguments you have, is what's in the best interest of the child. We've got rid of the presumption that the best interest is 50-50 shared parenting, and safety is of paramount importance for the children, as are what their best interests are. And one thing to take away that we'll discuss again next week is that parental responsibility isn't the same as the time that's shared. So just because someone may have 70% custody and you have 30% custody of your children, it is possible for you to have equal decision making. So those important decisions around where do they go to school, where do they get baptised, when and where do they go on holidays can be shared with a parent who doesn't even have 100% custody. So it really is important to make sure that you consider what the interests are of the children with any arguments you're making around where they should live after a parental separation.
Andrew, thank you very much for your time this morning. Great information, and I'd like to thank all of the callers that got involved with the program. Thank you again.
Likewise, thank you, and thank you to the callers.
All right. A copy
You've
of
been
this...
listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.